I'm pleased to be with Harry Littman of @TalkingFeds on YouTube, who also sits at the intersection of law and politics. I'm Michael Popak. I'm so pleased, longtime listener, first-time caller, Harry, and I'm really pleased to be here with you. I'm a big fan of your work and your background as federal prosecutor, U.S. attorney, assistant U.S. attorney, line prosecutor. You got it all, and you bring it all together on that @TalkingFeds. And I thought this was a great opportunity with all the developments that have happened just in the last couple of hours in the D.C. election interference case presided over by Judge Chutkan with special counsel Jack Smith. He's filing things that we expected, some of which we didn't expect, a new process that's in place, and you and I trying to read the tea leaves about what it all means. And an order by Judge Chutkan. We thought we were going to do a hot take and talk about things through the Talking Feds lens about 180-page filing. Now we learn there's a giant appendix, and we're not going to see the 180 pages, but we can glean some things from what Jack Smith has filed in his moving papers. Why don't you tell the audience all about that?
Yeah, well, really, Michael, when we were talking, you're the one who pointed out to me, they've given Trump an extra chunk of time, 10 days until the 10th, to respond on the appendix. And that's a pretty good indication that as just thinking about it, that it's a real doorstop. That's what tends to repose in appendices, just big old documents. But it's important to note the government is treating them differently. So the way we got here, they filed their 180-page brief, which they get special leave to do, and Trump opposes. And it seemed to me the immediate question was, would any evidence in there be made public and before the election? Because people have been talking about having a trial. Then they were talking about a mini trial. None of that is in the offing, but it may well be that it's certainly true that in that 180-page text, there's some characterization, say, of Michael Pence's testimony in the grand jury or Mark Meadows's testimony. Recall that he partially cooperated with Jack Smith without an immunity agreement. There's some incendiary stuff in there, you can be sure. And what happened is, by the protective order that Chutkan had entered long ago, after they made this filing, you just go automatically to the redaction stage because their filing was with redactions, and that represents what they say should be protected, even if, Judge, you make this public, and that's now exactly what's being litigated. So to the extent, if they were to win this motion outright and win it before the election, some really explosive stuff would emerge about Trump. And that's the eye that everyone should, that's the ball that everyone should keep their eye on now. What could come out? Okay, so basically the law here is, before we think about immunity, the law is there's a standard kind of legal rule and a 6-part test under the Hubbard case for when materials should stay redacted, notwithstanding what is a general public right to have transparency in the process. And I think you are going to see here, Michael, not just the DOJ, but media representatives with hotshot white shoe lawyers coming in to argue for it. And what the department has basically said in its motion about redaction is, we're going to redact names of people unless they're in the superseding indictment. So Mike Pence's name is not redacted, but basically witnesses who could be identified by Trump or crazy lone wolf Trump partisans, and they could be put in danger. That's the main thing. And then in the appendices themselves, they're going to redact like all sort of chunks of sensitive materials. But as I read their motion, they're going to do summaries of, for example, grand jury testimony or other things they rely on in saying in their 180-page motion, this is not immunized, which is, remember, the basic issue before the court. And that, to me, is what Trump is going to fight tooth and nail. So it's going to be really interesting to see what is his next move, because he's not thinking primarily about, what's immediately, in the long run sensitive or not. He's thinking about information not coming out, no October surprise. You could analogize to Jim Comey, who made those gratuitous statements about Hillary Clinton in October of 2016. If by just operation of law and the normal presumption of public access, some of this 180-page brief comes out and it say, for example, summarizes Mike Pence's testimony in the grand jury, man, oh man, that's going to be really explosive and play into the election for the same reasons people have thought that a trial would. He's been able to forestall in every way. This is his final fighting ground. Can he keep this evidence from being just put forward in the motion to deal with the immunity determination of paragraph by paragraph what should be immune? And I see him trying at his first opportunity to just freeze the linebackers and get it up to friendlier, more hospitable for him climbs, DC Circuit, but especially potentially the U.S. Supreme Court.
Yeah, I agree with you, Harry. He's been in every paper he's filed. He's done exactly what Judge Chutkan told him not to do. He uses every paper in the last 3 weeks to argue, Judge, just dismiss this on immunity grounds. You don't need to do any work. Don't let him file a brief, that bad person, special counsel Jack Smith, and don't let him file an appendix. That's even worse. Don't put any of this evidence into the public record, and certainly not before the election. Do it another way. And we don't like the way you're doing it. Let's take up on appeal and see if we can stop it, because we don't want any. So they're going to argue, as you outlined, and Ben and I were talking about it too. They're going to argue on some sort of appeal that the whole process that Judge Chutkan has established with her briefing schedule and allowing the government to go first and put in all this evidence to prove on the indictment, because I think you would probably agree. Normally, an indictment has to rise and fall in its own merits in the four corners of an indictment. You can't, you don't normally, as a prosecutor, when you need to defend your indictment, you're not able to say, but there was this great grand jury testimony that well, where is it in the indictment? Well, it's not there. Well, okay, that's evidence for trial, but you got to get over the hump of your indictment surviving a motion to dismiss. But this is not a motion to dismiss being brought by a defendant. Yeah. This is a defense of a superseding indictment and a call for immunity non-application by the special prosecutor. That's why Chutkan is allowing 2 briefs. And then some people might be saying, well, if there's a page limit for briefs, is there a page limit for appendix? No. Yeah. And I've been known to file thousands of pages.
As has the Department of Justice. Yeah.
Absolutely. Like, what happened to the 145 pages? Like, well, no, or 180 pages. No, I'm sorry. That doesn't count this mountain of evidence I'm going to present. So I agree with you. I think John Sauer is going to try to take it up. First stop, DC Court of Appeals. Having the Supreme, let me ask you this question, Harry. The Supreme Court having previously rejected Jack Smith's attempt to skip a step and go right to the Supreme Court initially in this case, which got us to the DC Court of Appeals, the immunity decision, and all the delays. Do you think that even this right-wing Supreme Court is going to allow him to take a direct appeal to the Supreme Court on this issue of briefing and redaction?
My best guess is he won't try. And then into the DC Circuit, we know where they were before, and very much with Judge Chutkan, a bipartisan panel, impeccably reasoned. But here can't come the 9 to really clobber them. And we actually had a leaked memo in the case where Chief Justice Roberts advised all his colleagues, the other 8, that he just tore the DC Circuit's reasoning to shreds. I think very illogically, or very, it just portended what they were going to do with immunity. And that is the basic battle here. They've come out and done the regular process as the DOJ. Here's the Hubbard case. Here are the 6 factors. What Trump is going to say is, we're talking immunity here. USA versus Trump changed the entire landscape. You can't talk about this anymore, because if you even let this evidence out of the bag, that is the opprobrium, that's the word he used, and the court adopted of the in the election that will fall on him. Because if you think about it, what is it about evidence, even if it's immune or shouldn't come forward, why shouldn't that be made public? All the time, every day, courts consider evidence to consider should it go before a jury. That's a public process when they do that. And even if they decide the jury can't see it for whatever reason, that doesn't mean the people can't. But Trump is going to argue for a much broader right having to do with it not even coming to the public at all. That's a whole, new kind of extension of immunity. The immediate, practical, nerdy question here, Michael, is can he make the argument long enough to run out the clock on November 5th? Because that's the real goal here.
Yeah, and we have a October 10th cutoff date for the judge just to get Trump, and then she's going to have her work cut out for her and her clerks because she's going to have to do line reading of the two comparisons while maybe dealing with these appellate issues.
And this is just the redactions, right? But you're 100% right. This is a painstaking plotting process. And they want the DOJ and Chutkan for it to go up only one more time.
That's right.
And Trump will be happy with 11 more times. It's a mess.
It's a total mess. I'm talking to Harry Litman, but he's Talking Feds. So if you go to @TalkingFeds on YouTube, a collaborative channel with MeidasTouch Network, you're going to find all of Harry's work and his podcast there. And I'd love to have Harry have you come on Legal AF with Karen and or with Ben on our edition. We've got a new YouTube channel too that we just started. We're 10 days old. It's @LegalAFMTN for MeidasTouch Network, where we're sitting at the intersection of law and politics like you and doing it our way. This was a real pleasure, Harry. I can't
It's
think
a date. It's a date now that I know what the acronym means. And in fact, actually, Karen, I'm an old enough fuddy-duddy that she had to explain the Legal AF part to me, but now I know the whole thing.
The analysis.
So see you on the Legal AF MTN.
Yes, fantastic. Yes, we don't reveal the actual Legal AF part, but what I normally say in my hot takes is that Ben and I named it 4 years ago, and then I just tell the story of whatever I'm telling, and then I say, and now you know why. And if you don't, join us on Wednesdays and Saturdays.
Now it has been told. All righty.
Yes. Harry Litman, Harry Litman, Talking Feds with Legal AF. Real pleasure. See you next time, Harry.
See you next time, Michael. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.